Hello all. Today we are going to discuss one another most important topic of Indian polity where questions are asked at most. So today we are going to discuss about the separations of powers among various organs. In a democracy, a government is formed by the people and this government is distinguished into three types. One is the legislature, another one is the executive, another one is judiciary. So here legislature is a body who is responsible for making laws, so it is a law making body. Our MP and MLAs who create laws from parliament and state legislature. And the executives are one who implement the laws made by the legislatures. And then judiciary is a watchdog mechanism to have a checks and balance between legislature and executive. So here the legislative and executive are interdependent. They are interdependent. Okay, let us discuss one by one. Here the executives, those who are all the executives: the president, the governor, vice president, PM, CM, and council of ministers. They are all the executives who is a legislature as well as an executive and a bureaucratic officers. So IAS officials, those who are also called as executives. So from this we can find that a legislature is a law-making body where executive was implementing the laws made by the legislatures, and judiciary, it is a checks and balance to have what is going around between the legislature and executives. Okay. So first and foremost thing we are going to discuss is separation of powers. So in this separation of powers, the political doctrine where yes, the legislature, the executive and judiciary independently functions. So these three are functioned independently. They are not influenced by one another. Okay. Here they also act as checks and balance between one another. The main aim of the objective to give the separation of powers among these three organs is to prevent the concentration of power from a single entity. And then to ensure liberty. And then to promote accountability. Every action should be accountable. So these are the main objectives of giving the separations of powers among various organs. Okay, let us discuss about the president. So the president, our Indian constitution covers articles from 52 to 78 and he comes under the part 5, which is the central government. He is an executive of central government. So president is called as the first citizen of India. He is called as the first citizen of India. And then president is called as the nominal head. President is called the nominal head. Every actions or any transaction about India is taken in the name of president. Okay. How a president is elected? So what we know is a president is a person whomsoever take the charge used to sign. So they turn the bill into an act. So after passing the bill in Lok Sabha and Rajya Sabha with the absolute majority, then it is sent to president for getting the assent. So let us discuss one by one. So first, how a president is being elected. So president is elected indirectly. He is elected indirectly. People does not involve in choosing him. People does not involve to choose him. So then how he is being elected is, he is elected by an electoral college. So he is elected by an electoral college. So those who are all present in the electoral colleges are the elected members of both Lok Sabha and Rajya Sabha. So here have a note that both elected members only elected members are chosen to vote in the presidential election. So no nominated members comes to vote for president. No nominated MPs vote for president. And then the elected members of state legislature. So here also elected members of state legislature alone participates, and then state legislative council, the members of state legislative council will not take part in this presidential election, because in India we have only at 6 states. We have state legislative councils at only at 6 states. So we will not give them the chance of electing. And then the elected members of union territories. The elected members of union territories like Delhi, Pondicherry and Jammu Kashmir, which means the union territory with state legislature. Union territory with state legislature. Okay, so how they are elected, how a president is being elected is, he is elected by an electoral college. Okay, so who are all the members participate in this electoral colleges are only the elected members. In this, no nominated members participate. No nominated members participate. Okay, so the elected members of both Lok Sabha and Rajya Sabha, elected members of state legislative assembly and elected members of union territories with state legislature. Here, the value of vote of each MLA varies from state to state. Why does it so? Why the value of each vote of MLA varies from state to state? Because of population. Territorial constituencies has been demarked on behalf of population. So in UP there are around 480 MLA seats. In Telangana there are only 119 seats. In Andhra Pradesh there is 175 seats. So based on this, the value of vote of each MLA varies by state to state. It is a previous year question asked by UPSC. Okay, then what about the value of vote of each MP? In sense of MP, the value is same. Value of MP is absolutely same, because only the elected persons are voted and no nominated persons are unable to vote. Okay, and then how does this election happens? How does this election occurs? The election occurs by the proportional representation method. So election takes place by proportional representation by single transferable vote, and voting is a secret ballot. So it is not conducted by any EVM or anything else. It is still the presidential election is done by the secret ballots. Okay. Whenever an issue rises on behalf of the presidential election, it is solved by the Supreme Court. So Supreme Court is the sole authority to solve the disputes which arises with the reference to the elections of presidents. So sole authority is Supreme Court. If MP or MLA has election dispute, he or she must visit High Court. So this is the difference. Have a look on it. And then what is his qualification? His qualification must be 35 years plus age. So his qualification might be 35 years plus age. He should be a qualified member for Lok Sabha. his qualification is needed to have a qualified member for Lok Sabha. What is the qualification of Lok Sabha? He must be a citizen of India. He needs to be more than 25 years of age, but for president we choose 35 years of age. Okay, that is the only difference. Okay, and then how his oath ceremony is administered. Chief Justice of India administers the oath ceremony. So only president has a oath ceremony with CJI, and CJI is having a oath ceremony with president. Okay, what is the condition of office? So what is his condition is, he should not be a member of either house. He should not be a member of either house, which means the Lok Sabha or Rajya Sabha. And then he should not involved in any office of profit. What is the meaning of office of profit? Office of profit is that he should not get any another salary from the government. So he'll be getting only the president's salary alone. So he should not involve with any of the office of profit. And according to Article 14, right to equality, we have one more thing, that at some cases we have some immunity. To a president we have some immunity, like if he is being a president, he has given the immunity from criminal proceedings. If it is his personal, even it is his personal, he could not be called for trial, or he could not be, the case cannot be registered. Case cannot be registered. So president is given a complete immune to be free from criminal proceedings. But what if civil proceedings takes place? If he has any civil cases along with him, he need to be notified 2 months prior. So he need to be notified 2 months prior. So 2 months notice in civil proceedings during the term should be given. So this is his condition of office. And what is his term, sir? Usually he discharge his duty for 5 years. He discharged his duties for 5 years. And then if he wishes to resign, if he or she is wishing to resign the post, they should send the resignation to the vice president. Resignation to vice president. We all know that if a person who is to be resigned, he needs to submit it to the superior officer. Superior officer. Resignation must be submitted to the superior officer. But here the president is at most superior. President is at most superior. So his resignation must be given to the Vice President of India. And he is eligible for reappointment for any number of terms. He can be reappointment for any number of terms without any hesitation. So he usually discharges his duties for 5 years. If he wishes to resign, he should submit his resignation to the Vice President, and he is eligible for reappointment for any number of times. Okay. Next, we could go to impeachment. What is meant by impeachment? Impeachment means disqualifying. When do a president can be disqualified? So impeachment is happening only for violation of constitution. If a constitution of India is violated by the president, if the fundamental rights to the citizens from 14 to 32 is violated, or any other provisions of the constitution is being violated by the president, then he must undergo impeachment process. How does the impeachment process takes place, sir? It is initiated by either house of the parliament. Either Lok Sabha or Rajya Sabha can initiate a bill for impeachment of the president, and then it should be signed by 1/4 of the member. It should be signed by 1/4 of the member. If there are 100 members in the house, then 25 members need to sign and initiate this bill. And then a prior notice of 14 days of notice must be given to him. priorly he must be given a notice of 14 days. And then if all things happen in a line, then the resolution to be passed by special majority by both the houses. What is meant by special majority? Special majority is that 2 by 3 members of present and voting. 2 by 3 members of present and voting. So, if the resolution passes, when do the resolution passes? It should be initiated in either house of the parliament. It should be signed by 1/4 of the member and a 14 days prior notice to be given to the president. And if the resolution is passed by the special majority by both the houses, not a single house. So the resolution to be passed in both the houses. So what is meant by special majority is that 2 by 3 members are present and voting. If there are 300 members in the parliament and 200 plus members to be voted in favor of impeachment. Voted in favor of impeachment. And then the bill gets passed. So here the elected plus nominated members of both Lok Sabha and Rajya Sabha participate. Because during the time of election, we noticed that only the elected members of Lok Sabha and Rajya Sabha participate. No nominated members can participate in the elections of president election, right? So in this manner, only elected and nominated members of Lok Sabha and Rajya Sabha do voting, and then no member from state legislature or union territory are entitled to vote. So entitled to vote. If a president is needed to be impeached, then who would be taking part in this election is, which is the voting day, is only the members of Lok Sabha and Rajya Sabha. Either they might be a nominated member or a elected member. So both the persons would be taking part. No role for state legislative assemblies as well as union territory legislatures. So have a look on it. It is one of the previous year question asked by UPSC. Okay, let us discuss the powers of presidents. What are all the powers does president has? So first, let us discuss one by one. Executive power. What is meant by executive? Executive is implementing the law. Implementing the laws. So here, the executive power of the Union of India is entirely vested with president. So who is the boss of Indian government? President is the boss of the Indian government, which means not Indian government, Union of India. To the entire India, he is the owner and he is the boss. And he makes rules for transaction of business. And he makes rules for transaction of business like union government. He appoints the prime minister. Whom do he appoints? A prime minister from the majority party. And then he appoints the council of ministers, data given by the prime minister, and he appoints the attorney general, who is the central government's advocate. Central government's advocate. And then here comes the CAG, Comptroller and Audit General. He is being appointed by the President of India, and then President appoints the governors. So, and then so many things like National Finance Commission, NCBC, National Commission for Backward Class, and Linguistic Officer, etc. These are all the posts appointed by the President of India. So, executive actions. What are all the powers does executive he has? Yes, every transaction of business is taken in name of President only. So, and then now we are moving to the legislative part. What do he do during the time of legislature? So, he summons. Summons means he calls for a meeting, and then he prorogues, he completes the meeting, and then he dissolves. If a Lok Sabha to be dissolved, he will be dissolving it. So the three major role is he would be summoning the parliament, he would be proroguing the parliament, and he would be dissolving the Lok Sabha only, not parliament, because Lok Sabha is able to be dissolved because Rajya Sabha is a complete house without an end. It is a continuous chamber. It is a continuous chamber. Okay. And then what he will do is he appoints speakers, deputy speakers when the office is vacant. If there is no role of speaker, then he appoints a person from that party to a role of speaker. First, he appoints a pro tem speaker. After entering into the parliament, after completing the general elections, President of India appoints a pro tem speaker. Pro tem speaker is the person who makes oath and affirmation for all the MPs. Okay. And then he nominates 12 personalities to Rajya Sabha. Whom do he nominates? A person who is from a good cultural work, from art, from sports, etc. So whomsoever we can example it is Ranjan Gogoi, former Chief Justice of India, Sudha Murthy, industrialist, etc. And then he decides the disqualification of a members with the election commission issue. So he decides the disqualification of members. If a election commission, if there is a defection, president makes a call with the election commission and then decides whether the member of the parliament to be disqualified or not. And then he issues ordinance. Ordinance means an immediate law. Now we have passed an ordinance like gambling games to be prohibited in India. So these are his executive and legislative powers. Okay. And then here comes the financial power. What he can do, he is considered as the purse. He should be prayerly get recommendation about a money bill. A money bill is passed only in the Lok Sabha. A money bill is passed only in the Lok Sabha because it is called the House of People. So if a bill is to be passed based on money, a prior recommendation of president is mandatory. Without the approval of president, the money bill cannot be introduced in the Lok Sabha. And then the union budget after the president's summon. So after summoning for calling for a meeting, then union budget to be presented there. And he constitute the finance commission. Why do we have finance commission? To devolve the funds among states. So devolve funds among states. Okay, these are his financial powers. In judiciary, what he would do is he appoints the Chief Justice of India. The collegium people, Chief Justice of India plus 4 other senior most judges of Supreme Court represents the collegium, and they advise a person to become the Chief Justice of India, and he is appointed by the President of India. And then judges of Supreme Court and High Court are appointed by the President of India after having a contact with the Chief Justice of India as well as the Chief Justice of that particular state and the Governor of the state. He also seek advice from Supreme Court. Advisory jurisdiction is given in Article 143. So advisory jurisdiction is given in the Article 143. If he has any issues, if he has any doubts regarding the bill or anything else regarding India, if he needs any legal matter of advice, then he seeks the advice from Supreme Court. And then he grants pardon, a relief. And then he commute punishments. So he also commute punishments. Okay, these are his judicial powers. Then what do veto power do the president has is, he has 3 alternatives for a bills. If a bill is passed in the Lok Sabha and Rajya Sabha with a special majority or simple majority, then it is sent to the bill for assent. So if he has 3 veto powers. One is the thing is he can assent. So it is, if he signs, that is called assent. If he signs, then the bill becomes act. Then he has the chance of withholding it. So he is not interested to do. So he can withhold it, or else he tells them to return. If there is if there is a chance for a need, it should be revised and updated. So he has three veto power. One is to give sign, which is the assent. Another one is the withhold. Another one is the return. From 1976, we follow that president is a person. President is a person who is obliged to sign the bills which passed from the parliament. So 1976 is the Cold War era between the Supreme Court and the Government of India. So these are all the powers of president. So we have seen about the executive power, we have seen about the legislative power, financial power, judicial power, as well as the veto power. Okay. So the veto power, President of India enjoys three veto. One is the absolute veto, another one is suspensive veto, another one is pocket veto. Okay, let us discuss one by one. So what is meant by absolute veto? So absolute veto is one to withhold his assent to the bill, then bill ends. If he is not interested to sign the bill, then the bill is completed. So it is available only for private member bill. It is only available for private member bill and not for a public bill, which means private member is a member of parliament who is not a part of government, which means he is not a part of Prime Minister and Council of Ministers. So these executives makes the public member bill, which is the government bill, and rest of the members who shares a bill, it is called a private member bill. And then it is possible when the cabinet resigns. So cabinet resigns, then it becomes absolute veto is applicable. And then here comes the suspensive veto. The suspensive veto when he returns the bill for reconsideration. So suspensive veto is applied when the bill is sent to the parliament once again for reconsideration. So have some changes and just update it. So that is called suspensive veto. But the suspensive veto is not available for money bill. So money bill don't holds suspensive veto. No suspensive veto because it is a prior permission asked by him. It is a prior permission granted by him. So money bill cannot be used under the suspensive veto. And here comes the pocket veto. What is meant by pocket veto is he is just keeping in his pocket. So which means he don't take action for an indefinite time. So no action. That is called pocket veto. So no pocket veto is available for constitutional amendment bill because constitutional amendment bill is a bill passed by the government. So there is no pocket veto for government bill. So Indian pocket veto is exactly wider than American pocket veto. So there might be a question, Indian pocket veto is much wider than American. There might be a statement. If there is a statement, then the statement is right. Okay. So we saw that President is responsible for every actions taken by the union government. Do he or she has any powers over the states? Yes, they do have powers over the states. So he too has a veto power over state bills. If a state legislative assembly passes a bill and the bills are sent to the governor for assent, he too has the same option. Like once he can assent or he can withhold or he can return. And then one more option he has is he can reserve the bill for the president. So he can reserve the bill for the president. Okay. So what does the Article 200 speaks is governor has four choices to consider a bill, like either he can assent the bill, either he can withhold it or return it, and then he has one more additional feature is he can reserve it for the president. If a bill is reserved for president, what does the Article 201 of Indian Constitution speaks? If a bill is reserved for the president's consideration, he has three options. One is assenting it or withholding the assent or directing the governor to return the bill to the state legislative assembly. So he has three options. One is giving assent to the bill or withholding the assent, or else to give the direct or to send the directions to the governor to return the bill to the state legislative assembly. And then one more most important point is president is not bound to give assent to the bill. President is not bounded, which is not binding. It is not binding to give assent to a bill. So 142 of the Indian Constitution speaks about Supreme Court has the role of playing the president's role if a president role or a governor role if for a long time the bill has been stopped. So it is in this current affairs. Have a look on it. There might be a question in prelims and mains. Okay, ordinance making power. What does the ordinance means? Immediate law. So when the president gets the chance for ordinance making power, so ordinance making power covers from the article 123. So the president to promulgate ordinances during the recess of parliament. If the parliament is not in session or the house is not in session. Okay. Let us discuss that, because we know that Rajya Sabha is a never-ending chamber, which is a continuous chamber. So he can promulgate only when both Lok Sabha and Rajya Sabha are not in session. So if there is no session, then he cannot. If there is no session in the parliament, then he can promulgate ordinance. And then if either of the house is not in session, and then he can promulgate ordinance. And then only when he is satisfied to take action. So this ordinance is taken into action only when he is satisfied to take action. So this satisfaction is under judicial review. What is meant by judicial review? According to Article 13 of the Indian Constitution speaks that whatever law or any changes bringing to the Constitution of India, it should be reviewed, because judiciary is the watchdog person to have checks and balance, right? So that is the main intention, that his satisfaction is also under judicial review. There might be a question that is president's satisfaction is under judicial review. Absolutely yes. If he passes an ordinance, do it completely follows? No. The expiry is 6 weeks and the maximum life is 6 months, 6 weeks. So to bring out the ordinance into an act, the parliament has to be reassembled by both the houses, must approve the bill to become an act. So if an ordinance is passed, its maximum life period, its expiry term is 6 weeks to 6 months, 6 weeks. Okay, maximum life is 6 months, 6 weeks. Prior that, the parliament has to be joined and it should be taken into action, and both houses should be passed here to become the act. Okay. And then he can issue ordinance. Yes, president is entitled to promulgate ordinance, but only when on the aid and advice of Council of Ministers only. If any ordinance to be passed, it comes from the advice of Council of Ministers. So PM has Council of Ministers for his assistance and President has PM for his assistant. So PM acts as the bridge between Prime Minister and President and Council of Ministers. So ordinance cannot be issued to amend the constitution. If an amendment is to be taken in the constitution, ordinance cannot be issued. Only a constitutional amendment bill has to be passed. No ordinances has the right to amend the constitution. And then the ordinance making power of a president is coextensive. It is a coextensive power of the president with the parliament, but not parallel action. So president must rely on Prime Minister and Council of Ministers for promulgating ordinances. If there is no chance of getting from the Prime Minister and Council of Ministers, he has the chance to bring ordinance that has expiry term of 6 weeks or maximum life of up to 6 months and 6 weeks, right? So his power is ordinance making power of the president is just a coextensive with the parliament, is right, but it is not a parallel. So he is not running a parallel government. Okay. And then here comes the pardoning power of the president. Okay, let us discuss about the pardoning power of president. Pardoning power means either he can completely absolve the conviction. Completely absolves the conviction. Either he can say, okay, you can leave. So the pardoning power of president is spoken in the article 72. So it is an executive power. So pardoning power of the president is an executive power because president is an executive and it is independent of judiciary. So judiciary can promulgate a verdict that a person who has been convicted in a case might be entitled for life sentence. If the person who is wishing to get the pardon from the president, he can reach president. Example, Nirbhaya case. 2011, a woman from Delhi has been gang raped and 5 members got arrested. And these 5 members were minor during that time. So later after post 2020, during the period of COVID-19, Supreme Court pronounced the verdict of life sentence, which means life sentence as well as death sentence. So they reached the president for absolving the conviction, but president rejected and they got hanged. So pardon means a completely absolving the conviction. So okay, we have some more types like pardon is completely absolving. So he is left free. And then commutation means it is a substitution to lighter punishment. If he has been announced or pronounced for 14 years of jail sentence, 14 years of jail, if a person who is good at his activities and who is maintaining some cordial relationship among the persons who are all present inside the jail, he can apply for commutation, and if president wishes, then his sentence could be reduced for 6 or 7 years. It is up to the president. It is up to the president. And then here comes the remission. So remission means reducing the period without changing the character of punishment. So remission, if 14 years sentence is given to the prisoner, if he applies for remission, he could be given 12 years, but the characteristics of the punishment is the same. If he has more severity here, the same severity would be followed here also. So in severity there is no change. And then here comes the respite. Respite means lesser sentence than original due to special facts. So like due to special facts in the sense, if a prisoner is pregnant or if he or she is disabled, at that time the family members used to approach for respite and they get a lesser sentence than original. So if he is convicted for 14 years, he has given a conviction for 14 years to have a life sentence. If the president, based on the special facts of holding the pregnancy or disability or anything else, if he or she wishes to give a particular period or reduce the period, like they might be giving 4 to 5 years, it is up to the president. Okay, and then here comes the reprieve. So reprieve means stop. Reprieve means stop. So giving stay on the execution for a temporary period. For a temporary period, it is being stopped. So in this pardoning power, we have seen 5 most important things is, one is pardon. Pardon means completely letting him free. Completely letting him free. And then we come to know about commutation. Commutation means a substitution to the lighter punishment. Commutation means substitution to the lighter punishment. And then here comes the remission. Remission means reducing period. The period is being reduced without changing the character of punishment. Okay. And then here comes the respite. Respite means lesser sentence due to original facts of special facts like pregnancy, disability, or something else. And reprieve means stopping for a temporary period. So these are all the pardoning power of the president, which speaks in the Article 72. It is an executive power. Okay, here comes the discretionary power. So discretionary power is a situational power. So discretionary power is situational. It does not arise all time. It does not arise all time. So this discretionary power is situational at when he appoints the PM and Council of Ministers when no majority in Lok Sabha or when PM dies in the office. Okay. So in 2024, after completing the 2024 election, we got a hung parliament because no single party got majority. So we have in Lok Sabha 543 members is the total number of MP seats. So the magic number is 50% plus 1 is 273. But no party has got the magic number of 273, where BJP got 240 seats. Indian National Congress got All India Congress Committee got just 99 seats. So the magic number was 273, and now a coalition government is running in the center with RJD, Rashtriya Janata Dal, plus Telugu Desam Party, plus some other parties, regional parties. So he appoints the PM and Council of Ministers when there is no particular majority in Lok Sabha. Or the PM, if a PM dies in the office, he needs to appoint someone as a PM and he needs to prove his majority. And then he dismisses the Council of Ministers when if a no confidence motion is approved. Okay. What is meant by no confidence motion? A no confidence motion means there is no support to government. No support to government. So here the required number is, the magic number is 273. If a bill is being passed or if a prime minister is entitled to prove his majority, he needs to prove that he has a majority of 273. He has support of 273 MPs. If he is unable to prove the majority by 273, then he needs to be dismissed. So if he is being dismissed, then the entire Council of Ministers should be dismissed. If a single person from Council of Ministers is entitled for no confidence motion, then if he falls for the no confidence motion, if no confidence motion is against the single minister is being passed, then the entire Council of Ministers should be dismissed, because Council of Ministers are collectively responsible to the lower house, which is the Lok Sabha. Collectively responsible to the Lok Sabha. Okay, and he can dissolve the Lok Sabha if Council of Ministers has lost the majority. Okay, so a discretionary power is a situational power, arises sometimes, it does not arises all the time. So if it arises, what he can do is he just appoints the PM and Council of Ministers when there is no particular majority from a single party. At that time he appoints and he asks the Prime Minister to prove his majority. Or else if a Prime Minister dies in the office, he himself chooses a person to become the Prime Minister and he asks them to prove his majority. And then if no confidence motion is being approved by the House, then he dismisses the Council of Ministers. And if the majority of the Council of Ministers is lost, then he dissolves the Lok Sabha. So some of the important facts of President is that Dr. Rajendra Prasad served as the President for twice in India. And then Neelam Sanjeeva Reddy was an unopposed President of India. Neelam Sanjeeva Reddy was an unopposed President in 1977. And Zakir Hussain was the first President. Zakir Hussain was the first President to die in the office of 1969. So V.V. Giri was the acting President. Some of the important facts is at most important one. UPSC might ask questions, so have a look on it. So Dr. Rajendra Prasad served as the President of India for twice. and he was the first president of India. And Neelam Sanjeeva Reddy was an unopposed president in 1977. Zakir Hussain was the first president to die in his office itself in the year 1969, and V.V. Giri was an acting president. So here we have completed the president's power. So we have seen the discretional powers, pardon power, and the other powers like ordinance making power and veto power, and we saw about this financial power, judicial power, and legislative power and executive powers. So this is a complete detail about the President of India. It is at most enough to travel, and it is at most enough to study. So have a great look on this, because every year question is being asked. Every year question is being asked. Two mains question could arise from here. Two mains question arises here, and two questions regarding the electoral college and the values of MLAs is being asked by UPSC every year. So have a great look here, have a wide knowledge here. Okay, let us discuss yet another topic called Vice President of India. So, Vice President, to assist the President and to discharge President's duty if President is sick or on leave. Okay, so he also acts as the ex officio chairperson of Rajya Sabha, which means whomsoever a person who comes and sits in the position of VP Vice President becomes the ex officio chairperson of Rajya Sabha, which is his power is similar to the Speaker of the Lok Sabha. He needs to conduct the business of the House. Okay, so in India it is the second highest office. So he is called the second citizen of India. The model which we follow is from American Vice President model. So Vice President is not also directly elected by the people. So he is also elected by electoral colleges of both houses only. So in President we had an electoral college like elected members of both the houses of Parliament, elected members of State Legislative Assembly, and elected members of Union Territory with Union Territory with Legislature. So this is the thing we have seen as the electoral college for President. But now for Vice President, here we have one more electoral college, which means it consists of both elected and nominated members of both the houses. So if a person who is being nominated by the President, 12 personalities, they too are entitled to vote. These 12 peoples are also entitled to vote in the election of Vice President. And then it does not include any of the state legislature, assembly or union territory. So this is the second highest office. Okay. So VP is also, the Vice President is also elected by the electoral colleges of only by both the houses, which is by Lok Sabha and Rajya Sabha, and no state legislative assembly or union territories will come here for the election. And then a difference between presidential election and vice presidential election is the nominated members of Lok Sabha or Rajya Sabha does not take part in presidential election, but they too take part in vice president's election. And then the election is by proportional representation by single transferable means of vote. Okay, what must be his qualifications, sir? His qualification is same as of president. Like qualification is 35 years of age to be completed, and he should be qualified for a member of Rajya Sabha. So he should be qualified for a member of Rajya Sabha, which means where president is to be qualified for a member of Lok Sabha, where vice president is entitled to qualified for a member of Rajya Sabha because he is the chairman of Rajya Sabha. And then most common point is no office of profit. He should not get any salary from any other government offices, right? So his term is also for 5 years. He can be removed from the office only by the resolution of Rajya Sabha. Only by the resolution of Rajya Sabha. So if he is need to be impeached or if he is need to be removed, he should be removed only by a resolution passed by the Rajya Sabha by its effective majority, which is 2/3 members present and voting. 2/3 members present and voting. And then it should be agreed by the Lok Sabha by 14 days from the notice given. So, does Constitution provides any grounds for the removal of Vice President? No, we don't have any removal procedure for Vice President. Okay. So, we have already said that he is the ex officio chairperson of Rajya Sabha and he is similar to the power of the Speaker. Okay. What do the Vice President do? Vice President is the person who will take care of the businesses of Rajya Sabha. So, whoever is being appointed as the Vice President of India will be taking part in the actions of conducting the rules of business in Rajya Sabha. So, role of a Vice President is to handle the house only. He don't discharges any duties. At sometimes he might act as a president if there is a vacancy. If there is a vacancy or like a vacancy like death or removal or anything else, but beyond 6 months he could not be in that post. Beyond 6 months. So at most period of a vice president can be a president is only a 6 months. So beyond 6 months he could not be there. And then Dr. Sarvapalli Radhakrishnan elected as vice president for 2 terms. And then Krishna Kant was the first vice president to die in the serving office. So in president we see a person, and then here in vice president we see Krishna Kant was the person to die in the serving office. Okay, vice president, is it most important? Yes, absolutely. For the year 2026, vice president is at most important because former vice president Jagdeep Dhankar resigned from his vice president post. So when the session of parliament next time meets, the vice president election would take place and vice president would be selected. And there are 2 people contesting. One is from India and another one is from India Alliance. Okay. So you should note the persons. So this Radhakrishnan name is coming once again that he would be the vice president of India based on the numbers. So CP Radhakrishnan, his mother has addressed that she kept his son the name Radhakrishnan based on the vice president of India, Dr. Radhakrishnan. So history repeats. He is also a Tamilan and he is also from Tamil Nadu. So this is about the vice president and nothing more to be discussed. Okay, now let us discuss yet another important concept, governor. So governor is also the most important one. He is a state head. He is the nominal head of the state. Okay. So what are all the articles he covers is Article 153 to 167. And then he comes under Part 6. Part 5 speaks about central government and Part 6 speaks about state government. So Article 153 to 167 speaks about the state executive. So governor is referred to the chief executive head. Likewise, every actions of the country is taken in the names of the President of India. By the same way, every executive action in the state is taken by the governor of the state. He is called as the nominal head of the state. He is called the nominal head of the state. So from the beginning, governor was tussle, and in this modern time, after some 2000s, there is a tussle between the governor and the chief minister of the state, because if an opposition party is ruling in the state, there is a pressure between the pressure and a tussle between the governor and the chief minister. So work is getting worried. It is not done effectively. So on this basis, there comes the 7th Constitutional Amendment Act 1956. So 7th Constitutional Amendment Act 1956 speaks that a same person can be a governor of two or more states. A same person can act as a governor for two or more states. In this previous slide, we have discussed about Dr. C.P. Radhakrishnan, right, who is going to be the Vice President of India. He was a governor from Maharashtra, and he has additional in charge in Pondicherry. So a same person can act as a governor for two or more states. So Jagdeep Dhankar, who was a former vice president, he was also a person of governor from the state West Bengal. And then how he is being appointed? Governor is appointed by president by his warrant under his seal. So governor is appointed by president by a warrant under his seal. Okay, he is just a central nominee but has independent office. He is a central government's nominee because he needs to report whether the state is traveling according to the constitution. He needs to report to the central government that the state government is pursuing on the basis of Indian constitution. If any terms, if it violates, he has the right to send to the president that he can propose for a president rule because of constitutional machinery failure, which speaks about Article 356 and 365. Please have a look on 356 and 365. So our model of appointment of governor is based on Canadian model of appointment of governor. So he is a central nominee to check whether the state is in accordance with the constitution or not, whether the central government advices are implemented here or not. If they violate anything, then he says it is a constitutional machinery failure and he proposes for president's rule. And then what is his qualification? He must be a citizen of India. He must have completed 35 years of age. So, Sarkaria Commission has given that a person who is going to be the governor of the state should not be from that particular state. So, if a person who is to be appointed a governor in Assam, he should be from outer parts of Assam, which means outer states of Assam. A person who is appointing as governor from Assam, except Assam, he can be from any other parts of India. So that is given by Sarkaria Commission's recommendation and it is not a constitutional provision. So in UPSC examination prelims, they could ask, so governor belonging to other state is a constitutional provision, whether the given statement is right or not. So if they ask, the question is absolutely wrong because it is given by Sarkaria, it is a recommendation by Sarkaria Commission only, it is not about the constitutional provision. Okay. Who makes oath administration to him? The Chief Justice of High Court. The Chief Justice of High Court makes the swearing ceremony. Okay, if Chief Justice comes to the High Court, he is being sworn in by the governor of the state. Okay, let us discuss about the conditions for office. The same as of president, he should not be a member of either house, no office of profit. He too holds the immune from criminal proceedings. So if he has any criminal violations or criminal cases, he has a immune. Even if it is a personal case, he has immune if he is in the seat of governor. And then no criminal proceeding during this term because it was asked in 2018, the same as president as well as governor holds the same criteria. For civil cases, civil proceedings, 2 months prior notice to be given to him. The same we have seen in the President of India also. So these are the qualifications of the governor of the state. Okay, Here, Article 158. Article 158 speaks about the emoluments and allowances of the governor shall not be diminished during his term of office. If a person who comes to the office of governor, if he is coming in the month of September 2025, till he goes out, he should be getting the amount of 3 lakh only. If it is revised, he can be getting an increment. If not, now the present salary of a governor is 3 lakh and he is getting 3 lakh. So during his entire tenure, it should not be diminished to 2,50,000, etc. So it is a constitutional immunity provided to them by not shrinking the allowances and emoluments. Okay. So usually governor is also entitled to be in this role for 5 years, but he can be stay in that post till the pleasure of president. If the president wishes to continue the same person in the state, same governor in the state, he can be the governor even after completing the tenure of 5 years. And here the pleasure is not under judicial review. Not under judicial review means it cannot be called in court. It cannot be called in court. The governor has no security of tenure. A person who get a post of governor, if he is there for 1 year and then he might be transferred to some other states, and then at that state he works for 5 years. But if the term is getting completed, he should not resign, or he must not be getting resigned till the pleasure of president. He continues to work there. Okay. So, and there is no ground specified for the removal of governor. So, removal of governor, we don't have any specified ground. And then the transfer of governors is done by the president. So, we have seen that if a person who is a governor in Assam for 1 year and then he is transferred to Manipur, then he serves as the Manipur governor for 1 to 5 years. Till 5 years. If he is being changed, then he goes to another state, there he completes his 5-year tenure. So even completing the 5-year tenure, he should not resign, or he will not be resigning his post, because it is subjected to the pleasure of president. If president wishes to continue him as the president of the governor of the state, he is entitled to move. And then reappointment in the same state is possible. So the reappointment of the governor in the same state, if a person is a governor in Assam, if he completes the 5 years tenure, if he is not transferred or no other notifications related to him, he will be the governor. If there comes a notification that Assam governor who has completed his tenure will be continuing for another 5 years, so this notification might be given. So reappointment of the same state is possible. If there is no governor, if the office of the governor is vacant, then who will discharge the duties of governor? Chief Justice of High Court may be appointed temporarily to discharge the duties of governor if the office is being vacant. So from this we can also add one more point, that if the President of India post is vacant, Vice President would be serving as the President of India. If the Vice President post is also vacant, then who will be discharging the duties of President? High Court. Likewise, the High Court Chief Justice, the Supreme Court Chief Justice, who is called the Chief Justice of India, will be delivering the duties of President. So have a greater look in this, brothers. Okay. Here comes the powers of the governor. What are all the powers of governor? Same as of the president. So he has executive power. Likewise, he appoints the CM, Advocate General of the State Election Commissioner, acts as the Chancellor of University in state. Some states has changed this from Chancellor is vested with the Chief Minister, but many states follow chancellor is handled by the governor. And in some tribal areas like Assam, Tripura, Meghalaya, Mizoram and other tribal areas, he appoints the tribal welfare minister. So tribal welfare minister is appointed by the governor of the state. Okay. What do he has in the legislative actions? So in legislative, he summons, he calls for a meeting, he prorogues, he completes the meeting and dissolves the state legislative assembly. Likewise, the president calls for parliament, governor calls for the state legislative assembly. And then the president nominates 12 members to Rajya Sabha. Here the governor nominates 1/6 of the members to the councils of legislative councils. The utmost strength of the legislative council should be 1/3 of members of legislative assemblies. If there are 100 MLAs and how much MLCs can be there is 33 MLCs only. So another actions regarding legislative he has is either he can give assent to a bill or withhold the assent or return bills, and also he can reserve for the bills for the consideration of president. Article 200 speaks about reserving the bill. A governor of a state can reserve a particular bill to the consideration of president. He too issues ordinance. The same practice after issuing ordinance, it should be passed in the legislative assembly. If there is a legislative council, it should be passed there also. Okay, what is his financial action is money bill. Likewise, the president, money bill is given a prior recommendation. Likewise, in the state, money bill comes out only with the prior recommendation of the governor. And then he constitutes state finance commission for every 5 years. There, president constitutes National Finance Commission for the devolution of funds to be shared between the states. Here in the State Finance Commission, he constitutes State Finance Commission to give devolution of funds to the local bodies. Devolution of funds to local bodies. Okay. What is his judicial power is? He is being consulted by the president while the appointments of judges of High Court is done. We have discussed that president will be discussing the Chief Justice of India and Chief Justice of the High Court and Governor of the High Court for appointing the judge of the High Court. And he has pardoning power. He has a pardoning power except death sentence. So death sentence is completely vested with the President of India because he is the superior authority in India. And he too holds the veto power. For ordinary laws, governor has 4 alternatives. Veto power, president has 3 alternatives, either to assent or withhold or return. But for governor, we have one more thing is either assent or withhold or return or reserve a bill for a president's consideration. But in money bill, he has only 3 alternatives. For money bill, he has only 3 alternatives because money bill is coming out only after the prior recommendation of president, the governor. Only prior recommendation of governor in the state. Okay. Then he cannot return bill for reconsideration because it gets into the parliament or legislature. If a president signs, it enters into the parliament. If a governor signs, it enters into the state legislative assembly. Money bill is reserved by the governor for president when, if a money bill is being reserved by the governor for president, he has only 2 options. One is to assent or withhold, but president cannot return money bill. President cannot return money bill. One is he can sign or he can withhold. If it is a rarest of rare scenario is money bill is being reserved by the governor for the president is rarest of rare scenario. Okay, let us see the ordinance making powers. So ordinance making power of president speaks in the article 123, where the ordinance making power of the governor speaks in the article 230. So it promulgates the ordinance when both are either of the houses not in session in case of bicameral. So if there is no bicameral, means there is only one house which is called the MLA's house, the legislative assembly. If there is no house in session, he can promulgate ordinance. And then it should be passed only when he is satisfied. So satisfaction is under judicial review by 44th Constitutional Amendment Act 1978. Sub same as president, He can also issue ordinance only on the aid and advice of Council of Ministers. And then ordinance making of power of President is coextensive with Parliament but not parallel. The same sense, the ordinance making of power is not a discretionary one. Sometimes President can instruct governor on ordinance making. If a governor finds some difficulties or if he is unable to know what to do, at that time President can instruct to do what to do and what not to do. Okay. Here comes the pardoning power of governor. So he too has pardon power except death sentence, commute, reprieve, respite and suspend convicted of any offence against state laws. So the same as of president, we too have the same pardoning power for the governor, but he don't have pardon for death sentence alone. But the governor can suspend, remit or commute death sentence. So what is meant by suspend, what is meant by remit and what is meant by commute? Please have a look in president's area. Okay, do the president, likewise the president, do the governor of the state has discretionary power? Yes, the governor of the state too holds the discretionary power. One is reservation of bills for the president consideration. It is his discretion. If a legislative assembly passes a bill, if a legislative assembly is passing a bill for governor, he can have four alternatives. One is giving assent or withholding it or returning it or reserving the bill for consideration of president. And then he can recommend the president rule like constitutional machinery failure. If they are not in the means of or they are not in the way of correlating with the central government or in the constitution, then he can recommend for president rules. And then the administration of adjoining union territories. So he can administer the adjoining union territories also if it is needed. And then seeking information from chief minister regarding the administrative and legislative policies. So how the president of India seeks the matters from prime minister, the same way seeking information from chief minister regarding administrative and legislative policies or discretionary powers of the governor. Additional discretion he has is establishment of separate development board. A separate development board for Maharashtra, Gujarat, Assam, Nagaland, Manipur, Sikkim, Arunachal Pradesh, Karnataka. These states has some special jurisdictions. In this way, they are coming under scheduled areas. So comes under fifth schedule. So at this areas, the governor has a discretion for creating a separate development board. So this is about the governor. Let us discuss about the prime minister and chief minister. So prime minister. Prime minister is a constitutional post for a union government, whereas chief minister is for a state government. Okay. Is there any special procedure specified in the constitution for the selection of PM? It is not mentioned. The same way, constitution has not specified any of the procedure for selection of CM. And then Article 75, which speaks that prime minister shall be appointed by president. It is discretionary. President has to appoint the leader of majority party in the Lok Sabha. We have discussed earlier. In the same way, Article 164, if articles are being forgotten to you, please remember that whatever articles in union, just add 89 to it, you will be getting the state legislative articles. So for union, from union to states, you need to know, just add the article 89. So please study about central government article alone. By adding 89, you would be repeating the same. Okay. When there is no majority, president can apply his discretion. So what we have seen is If there is no majority for any single party, then president uses his discretion and calls for a person to be elected as the prime minister. By the way, President Neelam Sanjeeva Reddy has appointed Charan Singh as the Prime Minister of India. The same way, Governor has to appoint the leader of the majority party in the State Legislative Assembly. If there is no majority, then Governor applies his discretion and calls any person to take charge as the Chief Minister. And then first, the President may appoint Prime Minister. If there is no majority, President might call a person to take charge as the PM, and then he need to prove his majority in Lok Sabha within a specified time. Within a specified time. Okay, in 1997, Supreme Court produced a verdict that a person who is not a member of either house can become a Prime Minister. And then if he becomes a Prime Minister, within 6 months, he should be a member either by Lok Sabha or Rajya Sabha. If he is participating in Lok Sabha, he need to contest in election. If he is to come from Rajya Sabha, he no need to contest in any elections. So by the elections of Rajya Sabha, he would be becoming a member of Rajya Sabha, and then he would act as the Prime Minister. Either the Prime Minister has come from Rajya Sabha, yes, from 2004 to 2014. 2004 to 2014, Dr. Manmohan Singh served as the Prime Minister of India. He was a member from Rajya Sabha. And then the same, a person who is not the member for either house of the State Legislative Assembly can also become a CM. After 6 months, he need to prove he is a member of either house. Example, during 2019 Maharashtra elections, Sir Uddhav Thackeray became the Chief Minister. He was not a member of either house because Maharashtra holds Legislative Assembly as well as Legislative Council. After becoming the Chief Minister, he came as a member from Legislative Council. So it should be noted here. And then the term of the Prime Minister is not fixed and holds office during the pleasure of President. Usually 5 years. After completing 5 years, if there is internal aggression or external war, what the President do is he would be extending the house for 1 more year. So he would be serving as the Prime Minister for yet another year, so 6 years. So it holds till the pleasure of President. And then here the same. Term is not fixed for Chief Minister and he holds office during the pleasure of the Governor. And then Article 78, much important article, which says that PM acts as the bridge between President and Council of Ministers. So he is the channel of communication between the President and Council of Ministers. Likewise, add 89 and find CM. Now let us discuss about the Council of Ministers. So Council of Ministers. As earlier discussed, Council of Ministers has 3 categories. One is a Cabinet Minister. Another one is Minister of State. Another one is Minister of Independent Church. So these 3 are the criteria for Council of Ministers. These 3 are the categories of Council of Ministers. Article 74 of the Indian Constitution speaks that Council of Ministers is to aid and advise the President. So President shall be act according to the advice tendered by the Council of Ministers. So President shall be act according to the advice tendered by the Council of Ministers, PM and Council of Ministers. The advices tendered by the Council of Ministers to the President shall not be inquired in any court. Could not be inquired in any court. Whatever the government proposes, the President does. So if any advices tendered by the ministers is not inquired in any court. In the same way, Article 163 speaks that Council with CM aid and advise, Council of Ministers and CM aid and advise the Governor except in his discretion alone. So in his discretion, he could not be advised. Yet all another matters, governor should act accordingly to the advice rendered by the Council of Ministers as well as the CM. So Article 65 speaks Council of Ministers on advice of PM is being appointed by President. So PM gives a list of Council of Ministers. It is appointed by the President of India. So after 2003, in the 91st Constitutional Amendment Act, it has confirmed that Council of Ministers along with PM shall not exceed 15% of Lok Sabha. So if there are 500 members in Lok Sabha, then 15% only should be a Prime Minister as well as the Council of Ministers. Only 75 members are entitled to become the Council of Ministers. The same holds for the state government also. So Council of Ministers hold office during the pleasure of President. It was asked twice in UPSC 2013 and UPSC 2007. And then here comes Article 75. When a Lok Sabha passes a no confidence motion against Council of Ministers, even a single Council of Ministers is entitled to for no confidence motion. All ministers should resign, including the members of Rajya Sabha. He should resign from the ministry, but he serves as the member of Rajya Sabha because it is a collective responsibility. So Council of Ministers is collectively responsible to the House of People. Why? Because people directly elects their representatives. That's the reason. So Council of Ministers is collectively responsible to the House of the People. And then here, just add 89 and find Article 164. Other ministers shall be appointed on the aid of advice of Chief Minister by Governor. If a member of either house is to be disqualified on defection, also disqualified to be appointed as ministers. So if a person who is from either house to be disqualified on defection, what is meant by defection? If he does not holds the words of the whip, he is entitled to defection. Appointed member, disqualified member can later become a minister too. Here the satisfaction of President is equal to the satisfaction of Council of Ministers because President acts according to the ideas stated by the Council of Ministers. So satisfaction of President is satisfaction of Council of Ministers. Council of Ministers is a constitutional body. So question might be asked, is Council of Ministers a constitutional body? Yes. Whereas Cabinet Ministers only mentioned. So Council of Ministers comes Cabinet Ministers, Minister of States, Minister of Independent Church. These three are the category. But Cabinet Ministers are only mentioned in Article 352. So Cabinet Minister was only added in Article 352. But originally it was not mentioned in the Constitution. Okay, and then the cabinet ministers are the actual power centers of the government. They supervise the Council of Ministers. So cabinet ministers are the head of the ministries. They are the actual power centers. They supervise the entire Council of Ministers, including the bureaucratic executives, secretaries. And finally, some of the constitutional, extra-constitutional body, cabinet committees. So cabinet committee is an extra-constitutional body provided by rules of business. Why cabinet committee is set up is to ensure the actions are done effectively. So it is set up by the Prime Minister as per requirement. If there is a requirement or if there is a need, it is set up by prime minister. So cabinet committees are set up by prime ministers. So cabinet ministry is chaired by the PM. So cabinet ministry is chaired by, he is the chairperson, prime minister is the chairperson. And then the appointments are, the appointments for economic affairs committee, he appoints committees of economic affairs, political affairs committee, security committee, investment and growth committee, skill development committee. So these are all the committees is appointed by the Prime Minister of India. And then the Parliamentary Affairs Committee is headed by Home Minister. So Parliamentary Affairs Committee is headed by or chaired by Home Ministers. And then here comes the Cabinet Secretariat. Cabinet Secretariat is a preparation of agenda of cabinet meetings, what to do, what not to do, what are the public importance they are going to discuss, etc. So here the secretarial assistance is given to the cabinet committees. So Cabinet Secretariat is a place where every actions are done and filed. So with this, we have completed the executive part as well as the legislative part. We have a judiciary part which is covered in the another video. Thank you.